Well, hello to everyone. We're going to make a start now, so I hope you're ready and sitting comfortably. We're in for a long session today. So a warm welcome to you all, and thank you very much for joining. If you haven't been on one of our webinars before, then I'm going to start by making a few introductions, if I may. So firstly, just so you know who you are listening to, I'm Karen Faulkner. I am the HR Knowledge Manager at HR Solutions. So I will be the lead presenter today, and I am joined by my colleague, Atim. She is here in the background just to field any technical problems should you have any. So of course, hopefully there will not be, but if you did have anything that she might be able to help you with, please just use the control panel with the section for questions, and she will do her best. We will be monitoring and collating any questions, so also do send us messages as we go, and you can always do so afterwards if you would like to. And I'll try and come back to you as soon as I can. As always though, we are recording this webinar, so you will be able to watch it again in the near future if you wanted to go back and refresh your memory. And we do have slides available. Now, we have added these to the handouts section on the control panel. So if you did just want to drop down that section, you should be able to download them. It's prefixed by today's date, so have a look there if you would like the notes to accompany. Well then, our topic today, we're still on GDPR. We've done a lot on GDPR, and you know it is in effect now, and we have our Data Protection Act 2018. A lot of the questions that are coming through on our advice lines are regarding privacy agreements, and consent, and there is a lot of confusion between the two. Sometimes they're being mixed up altogether. So we thought it would be a great way to wrap up our compliance session on GDPR by having a look at ironing out these two very important but distinct concepts. And seeing as how we got the Data Protection Act at the back end of last month, we thought we would also do a nod to anything in there that specifically refers to employment, so that we can be adding that to our ever-growing to-do list as well. Okay, so we do usually like to have a few aims. So hopefully by the end of this session, you will feel confident with what consent means, you know, in the context of data protection anyway. Hopefully you'll also understand how you can go about gaining consent in a way that is lawful. And you should know the difference between consent and a privacy agreement. That's my main aim for today anyway. Hopefully you will feel more comfortable about which we may need to issue to employees, and more importantly, when we would need to issue them. And I'm going to try and give you a few HR related tips as well on data protection, especially, as I say, now we've got this Data Protection Act in place. Okay, so there is a bit to get through. I will try and move on promptly, but hopefully whilst explaining it as we go. The first section of our session today then, first of three, we're going to look at consent. Now, on a day-to-day basis, we tend to connotate the word consent with other words like acceptance and agreement. And indeed, you may see those words used in relation to privacy as well, especially when you go online. Okay. But for the purpose of this session today, what I am going to ask is that you consider just wiping anything that you might have, you know, in terms of preconceived ideas about consent from your mind. So if we can go forwards with a bit of a blank slate, I think we may all be for the better in terms of rebuilding our knowledge about these concepts. Okay, so what is consent? Consent is a legal basis, okay? So what does that mean? Well, under GDPR, you must have a legal basis or a legal reason to have personal data in your organization in the first place. Okay, without a legal reason, you're not supposed to have any at all. So it's really important that we know what legal reason we have in order to have that data. Now, this legal reason is referred to as a legal basis. Okay, and there are 6 possible legal bases upon which we can use as a statutory excuse to have personal data in our organisation in the first place. Okay, and one of these is consent. Okay, so what is meant by consent in terms of properties? Okay, so it's a legal basis and it is defined by 4 properties. And you might have seen these around, okay? But for consent to properly exist and be valid, it must be freely given. It must be specific, it must be informed, and it must be unambiguous. Okay, so let's look at this in a little bit more detail. Freely given, in fact, is something that I'm going to concentrate on for a few more slides, because it is this aspect of consent which means that employers probably, or in my view, ought to be avoiding consent at all costs, really. And if you haven't been along to anything where I've explained that before, you know, this is where we really get into the nitty-gritty and the legal reasons behind that. Okay, specific. So the exact purposes of personal data must be explained in very clear and very plain language. With informed, we are actually given a prescribed list of information which a data subject must be given, okay, in an easily accessible form. And there must be a very clear and deliberate affirmative action by the data subject or by the employee to show that consent has really been given. Okay, and it's this last one, this unambiguous reason, as to why pre-ticked opt-in boxes are actually unlawful now. Okay, so if you ever see any that are pre-ticked, that is actually breaking the law. Okay, so you've got to have some sort of action where someone's very deliberately gone and said, yes, I'm happy for that to happen. Okay, it can't have happened by accident. All right. So freely given then. Consent has got to be freely given, and it can only be freely given if these 3 things apply. Okay, so again, this is set out by the GDPR. So when someone's giving consent, they must really have a genuine free choice to give that consent. Okay, they must also be able to withdraw that consent easily and at any time. And consent can only be given, and this is an important one, consent can only really be given in circumstances where there is always a balance of power. Okay, so the GDPR says that there is an imbalance in power when a controller or an employer can process some personal data about the subject or the employee by relying on another legal basis to do so. All right. Now, employers can rely on the legal basis called a legal obligation. All right. So again, if you've not come across this before, basically it means if we have got some legal obligation upon us, which means we have to have personal data in order to comply, then that is our legal basis for processing the data. Okay. Employers are usually going to be able to rely on that because that covers pretty much everything that we do, especially from a HR context. Okay. And wherever that doesn't, suffice, we're probably going to be able to rely on the other one to do with the performance of a contract. Okay, so most, if not all, of our employees' data we can justify processing because we've got an overriding legal obligation, or we need it in order to be able to perform that contract of employment. Okay, or to enter into that contract. So because we have got these other legal bases to be able to process some personal data, there is an imbalance of power in an employee-employer relationship, okay? And that means that consent cannot be freely given, okay? It means that consent probably cannot ever be freely given in an employee-employer relationship, because there is always going to be personal data that we process about our staff without needing their consent. Okay, so even if you engineer a situation where actually you could feel very confident that actually, no, we're not obligating staff, to sign this document. It's genuinely their free choice. They can take it back at any time. There will be no negative ramifications on them for doing that. Okay, even if that's true, the GDPR says that it is still likely that there will be an imbalance of power which overrides that situation that you've engineered, okay? Because in other circumstances, the employee does not have a free choice in your relationship. Okay. So, because there is this imbalance in power, consent cannot be freely given. And because freely given is one of the 4 defining characteristics that consent has to have, we cannot rely on consent to process employee data. So the common question that we are getting asked, do I have to obtain consent to process personal data of employees? Well, the resounding answer then is no. Okay, as I've said, so long as one of the other legal bases applies and data is processed in accordance with that legal basis, then we can process personal data lawfully without needing consent. Okay, so this is actually a good thing for us. Can you imagine a situation where an employee could approach you and say, hey, I don't want you to keep my disciplinary records anymore. It's just not going to work, is it? It's just not workable. So this is a good thing, really. But whenever you hear, people sounding off, you've got to have consent for everything. You can't do anything without consent anymore. In an employment context, that is simply not true. Okay. And I am talking about employment. I'm not getting involved in sales or marketing or anything like that. In an employment context, you do not need consent. And in fact, you shouldn't be getting consent to process personal data about your employees for HR and employment purposes. Okay. I mentioned legal obligation before. If you think about it straight away, we've got to comply with the Employment Rights Act. Everything in there that we do in HR, straight away is a legal obligation that gives us our basis for processing personal data. We've got TUPE regulations. We've got the working time regulations. We've got national minimum wage legislation. We've got the Equality Act and so on and so on. Okay, so we've got so many pieces of law that actually generate our jobs, as HR and employment law professionals. So no, we're rarely ever going to need consent because we've got all of those acts and regulations and laws to comply with that gives us this legal obligation to process personal data. Okay. Yeah, there is always going to be an exception, isn't there? Of course there is. I can only find one, okay, and I'm open to others being found. I think we're all helping each other as we go in a practical sense, because this is such a revolutionary piece of law. But when might you need your employees' consent? Okay, so if you have any other piece of law that applies to your industry, okay, that overrides data protection laws and says you must get consent, okay, then you might have to. Okay, now the only regular, let's say, way in which I think this could happen in a HR context is if you ever felt, okay, that a genuine situation had arisen where you needed to assess medical capability, okay. You may then need the consent of your employees if a situation arises such as that, okay, and you needed to know whether or not they were medically capable to perform in their role, okay. So this is only ever really going to be the case when something happens, which means you become concerned, okay, you become concerned about a deterioration in their performance, and you've got reason to believe or suggestions that this could be related to their health, okay. Equally, if they were to apply for a job with you and they tell you, you know, about something that they have and you need to offer adjustments, you know, similarly, that would be a situation where you become concerned that their performance, you know, might not be what it needs to be without some sort of support. Or if the job that they have requires a certain level of medical capability to do it, okay, as part of a regulatory or statutory requirement. So this is rare, but there are some jobs that require a certain level of fitness. Or if there were genuine concerns that might relate to drug and alcohol testing in a health and safety context, okay. If this is something that may apply to you, you've probably got a policy for it in place already, you know, especially if you're in an industry which is perhaps using really heavy equipment and machinery, for example. Okay, so the reason why you might still need to get consent in this situation is because there is entirely separate law on accessing medical records, okay, which requires consent. Okay, it's separate to the GDPR and it is going to supersede because the level of sensitivity that's involved. Now, when I put my head to it, I can only really think of one other situation where you might want something like consent, but I'm not convinced it is consent, so I've grayed this out. But I think this comes up quite a lot. So if an employee, for some reason, you know, especially when they might be struggling with something or, you know, they're being accompanied to a meeting, if they were to ask you to liaise with somebody else on their behalf, like a family member or a TU rep, you know, someone that's accompanying them, usually, as I say, if they say, look, can you send any information or correspondence directly to this person, you know, then you might start to feel a bit GDPR hat on, is this okay, is it not okay? Well, remember, they've asked you, you're not asking them, okay? So get evidence that that's the way round that it is, you know, just ask them to jot it in a letter or send you an email, okay? But because data protection is very much something where the onus of responsibility is on the employer, I think you'd be well advised to consider using the requirements of consent just to gain extra clarity and robustness to ensure that both parties understand, you know, what the employee's intention is, you know, to the extent to which they wanted you to share that information with their representative. Okay, you know, so exactly what, how long for, to who, the contact details of that person, you know, so you can't make mistakes or accidentally share it with somebody else. And, you know, how long they want you to keep doing that for, you know, those sorts of things. But remember, the direction here is them asking you and then you taking the liberty of clarifying the extent to which you're going to process it. And I think you take your guidance there from the principles of consent. Okay. So if you did feel that you needed to get consent for something, okay, and as I said, it's usually probably going to be when you're asking for access to medical records, then you need to ensure that all of these things are covered off in that form. Okay, so you've got the name of your organisation or who the data controller is, Okay, so that is your company name, usually embodied purely for the purpose of assigning responsibilities, you know, by the managing director or CEO or something like that. If you were giving it to any third parties who are also controllers, then you'd need to inform the individual of that as well, especially if they're also relying on the consent. You got to include the purpose of the processing, which, you know, stands to reason. So why you want their data and how you will actually process it. You've got to confirm to them that they may withdraw their consent at any time. And there should be a clear way in which they can confirm their consent. So I mentioned before about the fact there's got to be this affirmative action. We're quite used to seeing a line, aren't we, at the bottom of forms where you have to just pop your signature and then, you know, spell your name out as well. You know, so something like that is going to mean that someone's deliberately given their consent, you know, or if you've got opt-in boxes or anything like that, depending on the format that you're using. And then lastly, only if it's possible, but if you're perhaps asking for consent for a few different things, separate it out so that they can confirm their consent for A, B, and C, but not X, Y, and Z, you know, if that's what they wanted to be. You know, you've got to give them this choice as far as you possibly can. Okay. And the only last piece of information in the GDPR about the actual content of what you put in there is the fact that it can't include any unfair terms. So that's about as specific as it gets, I'm afraid. So we just have to apply the reasonable person test there, think about what may or may not be reasonable, you know, to the next person walking down the street, and try and avoid adding anything in like that, which is probably in your favour, you know. Okay. So that's what you have to include when you are obtaining consent, when you are obtaining your legal basis upon which to process personal data. Okay. If at the point of getting consent, you are also asking the individual to give you their personal data, okay, then you would have to include additional information as well, okay? So wrap your head around that just for a moment. So you're obtaining your legal basis of consent, you're giving them those bits of information that were listed in order to get consent, and you're including some sort of tick box or signature to confirm that they're happy for you to process their data in that way. Okay, that's kind of assuming you've already got their data. So it may quite often be the case actually that you put that bit to obtain consent at the bottom of some sort of form where you're also collecting data from an individual, okay? And the additional information that you have to give somebody when you're actually getting the data itself off them leads us onto privacy. Okay, so before we do that, consent in a summary. Firstly, consent is one of 6 lawful bases upon which you can justify collecting and processing personal data in the first place. Okay. Now, employers do not need to rely upon consent. Okay, they just don't need it before they can process employee data. Okay, and this is because of this imbalance in power in the employee-employer relationship. Okay, because actually we have obligations on us that mean regardless of whether you want us to have it or not, we have to have certain information about you. Okay, and if not, you can't work here, basically. So employers can't rely upon consent 9 times out of 10. You may still need consent if you need to request access to medical records, but only because that's covered by different legislation. Okay, and you should take away from this that there are certain things that must be included when you're getting consent for it to be lawful. Okay. So, moving on then to part 2, and let's look at privacy now. So again, if we could just take a moment and just have a think about privacy and what that word means. Most people are quite happy, that privacy is something we usually think about in relation to ourselves, how we keep our own personal business private, and how we keep our own goings on, confidential from a wider audience, and we only share it with certain person or family or friends or trusted parties, like a bank or something like that. And it's privacy is something when we want, to keep something from being disclosed from other people, without our control, and unlike before where I asked you to let go of what your idea about consent was, hang on to this notion of privacy. I think it will probably help you actually if we, go through this section by thinking about us in the shoes of a data subject, and how we want our data to be kept private from other people. But if you could perhaps again wipe the slate clean and come with me on a blank slate in terms of thinking about anything you might already know or think you know about privacy notices and agreements and things like that, okay? Leave that at the door just for now and just put yourself in the shoes of a data subject and someone who wants their information that is out there in other organisations to be kept private, okay? Now, first things first, okay? We're looking at privacy in the context of data protection, okay? Not domestic life or anything like that. And there is no legal definition for privacy in the GDPR, okay? Which is why we can hang on to this sense, of what it means on a day-to-day basis, okay? So there's no legal definition for what it is under the GDPR. Right. Privacy under the GDPR, I want you to think about just a set of information, okay? So under the GDPR, certain information must be provided to a data subject, to us, at the point at which an organisation is collecting your data, okay? And that information that an organisation is obliged to give you conveys why they collect your data, why they process it about you, how they use it, who they share it with, and what your rights are, okay? So you are fully informed about your privacy in terms of the information that is held in an organisation, okay? So in short, it explains to you, the data subject, why they have your data, how it will be restricted, and how they are going to help keep it private on your behalf. Okay. Now, this packet of information, if you will, is set out in Article 13. Okay, so if you've got any legal people or legal teams, and they want to know where to go and get it and write their own privacy information, this is where it comes from. Okay, now this sets out what information must be given to us as data subjects if an organization is getting our data from us directly, okay, rather than from another organization or another person. Okay. Now there are 14 things, or there's up to 14 things I should say, that may need to be conveyed to us if they're applicable. And if they are getting our data from another organisation, there are an additional 2 things, okay, that need to be conveyed. So if you start to think about yourself as an organisation collecting data and you're getting information about people from somewhere else, get in touch with us and I can help you out with that a bit more. but we're not going to look at that just now. But all of these things you only have to convey to a data subject if they don't already know it. Okay, so that sounds reasonable, but perhaps on a practical level it's going to be quite hard to go through and extract out all the different bits that you might have told specific people already. So you're probably always going to end up with a template, aren't you? Really? So I have included here what these 14 things are. It's not the legal wording. I've condensed it to be a bit more, well, just reader friendly, to be honest. So it's easier to wrap your head around. And I'm not going to dwell on these too much. Please pop back and look again, because there's an awful lot for us to get through today. But as I say, pop back and look and just hit pause and you can jot them down. It's pretty much the sort of thing you would expect, though, who you are, or who the organisation is rather, why you're collecting the data, the legal basis you're relying on, who you're sharing it with, how long you're keeping it for, what their rights are. You have to have been told that you have the right to lodge a complaint as well, if you're not happy with how an organisation might be dealing with your data. So you can see how, again, the onus of responsibility, with regards to informing people about data is very much on the controller, or on the employer. There's no secrets here. Oops. So those are the 14 things, okay? I just want you to have a look at this image. Okay, so if you have a look at this person standing up, all right, and envisage that she is writing those 14 things down on the board about how this organisation, this employer, processes personal information about these employees sitting down. Okay, she's jotting all of that up there for them. Now, she could leave that information on that whiteboard and, if staff come back to her or anyone else comes along and says, hey, as my employer, how are you processing my personal data? How are you looking after it? Who does it go to? So on and so forth. She could point them back to that whiteboard, okay, and say, have a look at all that information listed there. Now, she could refer to that information collectively as a privacy notice or a privacy statement, okay, or something similar. And so you start to see that actually these phrases, these are not something that exist in the GDPR. These are phrases that we have coined to collectively refer to that set of information, okay, that prescribed list of detail that the GDPR and previous data protection laws, to some extent, have told us we must provide to data subjects or to our employees. Okay. I mean, really, she can call it whatever she likes, within reason, so long as it conveys those 14 things, if they're applicable. So, she can do that. She might choose to put that information into a letter and issue it to all staff. Okay, fine. She might choose to put it into a letter and issue it to all staff, and she might ask them to pop their signature on the bottom and return one copy, to keep it on file. Okay, if she starts to call that a privacy agreement, or she refers to the signature, as indicate your acceptance here, is that something she really needs to do? Which leads us on to the next thing that we're regularly asked, okay? Do I need to give a privacy agreement, okay? Again, not a phrase that actually exists in the GDPR. The question we should probably be asking instead is, do I need to give privacy information to our employees? And the answer is yes. Okay, any data subject you collect information from, you must give privacy information to. Okay, so that could include job applicants, it could include self-employed contractors, it could even be visitors, if you're getting them to put their information down. Okay, any data subject you collect information from, you would need to give them this privacy information. So do you need a privacy agreement? Well, the answer is no. No. And in fact, asking them to agree, I think, is confusing. We started out by talking about consent, and often the word agree and accept is connotated with consent. And I do think this is where confusion starts to happen, okay? If you ask them to agree or accept the terms, it's misleading because you don't need their agreement. You've probably already established a legal reason to process their personal data in the first place. You don't need them to agree to that. You just need to tell them how you're keeping their information private. And then another common question, which is similar, do I need a privacy policy? Well, it's up to you. I know people in HR, we do love a good policy sometimes, but we can get carried away. Policies for everything. Consider whether it's relevant. If you think about a policy and what it's designed to do, set of rules, do your staff process a lot of personal data in their day-to-day jobs? Because maybe the nature of your business is that actually it might be wise for us to set out, what our rules are in respect of privacy so that they can go back and refer to something and know what we expect of them, then yeah, do yourself a privacy policy. Alternatively, you might just think it's a practical way of informing employees of how you keep their information private. But you would need to know that they've read that policy, But yeah, if you want a privacy policy, you can. And this is distinct from a data protection policy, of course, okay? You do have to have a data protection policy, but a privacy policy specifically, just for this information, up to you. So, do you need a privacy agreement? Summarising, the term privacy agreement, it doesn't appear in the GDPR, okay? Organisations are often attaching the word privacy to the word agreement, to the word acceptance. And it is where this confusion starts, okay? So in short, employers do not need to have an agreement as such. They might want to find a way of proving that they have met their obligation to provide this information directly to an employee or a data subject when they were supposed to. Okay. So I would put to you that when organisations are asking for you to accept their terms, it is more likely that they're finding a way of establishing that they've met their obligations and that they have chosen methods which are effective to meet those obligations. Okay. So yes, we are all going to have to give privacy information when we're collecting personal data from anybody when we're acting as a company. So what format does that need to take? So long as all that information is in there, then how you actually present it is entirely up to you, okay, including what you call it, okay? I would probably suggest that you stick to, a privacy notice or a privacy statement because it's just so much more neutral and it doesn't, imply that there's any kind of agreement or consent going on, okay? And then when you provide it, so I have mentioned a couple of times already, but it has got to be when you actually collect the data. So at that point specifically. And this information does have to be given directly to each individual employee. Okay, each individual, unless you determine this would involve a disproportionate effort. Okay. Now, whether or not it would involve a disproportionate effort is something that you would have to assess. You can't just on a whim decide it's a disproportionate effort, but something being a disproportionate effort is one of the legitimate legal excuses for not issuing privacy information directly to each person. Okay. And your assessment of that fact should weigh up these two factors here. So firstly, the level of effort that would be required to give that information to each person, and then also the effect that your use of their personal data is going to have on them. So the GDPR says you should consider the number of people involved, how relevant the personal data is, and any appropriate safeguards that might be in place to mitigate risks, and so on and so forth. Okay. Now, if you did do an assessment and you decided it was a disproportionate effort, then you would still have to ensure that all that information was available publicly somewhere. And you would have to have conducted a data protection impact assessment, okay, which you keep. So if you're called upon, or challenged over your practices, you can wheel that out, okay, quite happily. If you're not familiar with the data protection impact assessment, I do have an entire webinar actually on it as part of our compliance series, and I think it was the third one that we did. So feel free to jog your memories and have a look at that. So, a disproportionate effort. I've got an example for you just to try and help with that, really, because when I go out and do seminars and things about this, we quite often end up all discussing and talking about emergency contacts, because they are, of course, also data subjects, and we've probably got loads of them in our personnel files, and each of them are a data subject, So I'm going to discuss emergency contacts, and the example I'm going to give you actually is what the ICO do as an employer, because who better to take learning from than them themselves. So the ICO, they employ about 500 members of staff, okay, and so they've taken it upon themselves to assess whether it's proportionate to send out 500 letters, or maybe even 1,000, because we normally ask for 2 emergency contacts in case one doesn't work. Is it proportionate to send out 500 or even 1,000 letters to people who you actually may never ever have to contact? Is that proportionate to do? Well, they've determined that it may be disproportionate to write to each of those individually, with all of that privacy information. So instead what they do, and you can check out their website after this, or if you want to do it now, feel free, but don't turn me off. Instead, what they do in the privacy notice on their website, they explain that they ask employees for emergency contact details. And so it may be that they're in receipt of your data if one of their employees has provided it to them for this purpose. Okay, so that is there in their privacy statement for you to read. Now, when the ICO give guidance about emergency contacts and things, they do suggest, that you put those measures or safeguards in place, such as, ensuring that access is restricted, so not any old Joe blogs could just walk past and get hold of some poor emergency contact's phone number, and that the data is only ever truly used in the event of an emergency. And that you don't use it to add people to a mailing list or something like that, So there you go. Perhaps if you've got 500 staff, maybe you don't have to go through issuing those letters to all the emergency contacts as well. So some practical tips then on when to give privacy information to employees. Candidates, of course. Candidates are probably going to be where you first start collecting data about someone who could become an employee, and of course all candidates are data subjects. So when you are recruiting, consider making privacy information available. Okay, you're going to have to look at your own processes, of course, but think about how you can direct a candidate's attention to that information. If you get 500, or more candidates applying for jobs, maybe again you have a publicly available section on your recruitment page or on your website, and you might again in some sort of application form direct their attention to that. Okay, so take responsibility for ensuring people know where to go to find it. New employees. So it does say in the privacy information that if the purpose of the processing changes, then you need to let individuals know about that. And equally, it's likely that some of the other information will change too. So you'd need to let them know about those changes as well. Now, unless you had an all-encompassing privacy statement at the recruitment stage, it's likely that now a candidate has gone from a prospective employee to an employee, that the way you use their data is for an entirely different purpose. Before it was for filling a vacancy, and now it's for adhering to your obligations as an employer. Okay, so you may now need to write to them again at this point. So maybe you do it, maybe you convey the information when you're issuing some sort of new starter form, or when you're conducting a right to work check. These sorts of points are probably going to be where most people are prompted to look at issuing privacy information again. So again, think about your processes. If you're quite digital and you do everything on information systems, can you include a page or a section on the intranet or a web page about that? If you do use forms, you're probably rejigging them anyway to make sure you're not over collecting information, or it's segregated out so that only HR know what they need to know and only payroll know what they need to know, and so on. But perhaps you look at putting some privacy info on there too. Okay, and then for existing employees, perhaps as we're all probably still preparing for the GDPR, or most people are, you may want to consider putting together some sort of standardized letter to issue, and maybe that just goes out with everyone's pay slips, even if you've got 500 staff, given that you're probably providing them with a communication like a pay slip every month, means it's probably not disproportionate effort to issue one standardized letter and just attach it to everyone's pay slip, digitally or physically. But then going forwards, it's not likely you're ever going to really need to update staff with privacy information, only if something were to come about which meant that the reason for processing changed. Okay, let's say, for example, you did a variation to terms and you contractually offered benefits, and perhaps those benefits include a third party as well, because you've got this new contractual obligation in place, you've got your excuse to legally process data in a different way there to adhere to a contract, and the purpose has changed, and equally there's another party involved that you're sharing info with. So perhaps then, but otherwise I think it's rare. You will have to. But as I have done there, just try and preempt eventualities. Think about levers, probably rare that the purpose will change, but it might do. Agency staff, contractors, I've mentioned visitors and emergency contacts before as well. So go through the groups you're likely to come across as HR people. So clarifying the difference then between privacy and consent. Hopefully through all this you feel a little bit clearer, if not totally, on the two. But I hope all that discussion has led us to be able to quite succinctly define the two in these very brief ways. Okay, privacy is information, and consent is a legal basis that you may establish to have personal data. okay? Privacy is not a legal basis. It is just information that you convey to somebody about how you're protecting their data. And if someone acknowledges it, if someone acknowledges they've read it or accepted it, it's not the same as giving consent, okay? You might be asking for consent at the same time, but just giving privacy information alone is not the same as getting consent, okay? It may simply be that an organisation who does this is just wanting to prove that they've issued that information at the right time and that the method of giving access to that information was effective, okay? I mean, it could always be that someone's misusing privacy to try and get consent, but that's their problem, you know, not yours. So, last but not least, the Data Protection Act. It's here. If you heard about the Data Protection Bill, okay, so that is now gone. The Data Protection Bill has been passed and it's now turned into the Data Protection Act 2018, okay? So just for anyone who's not familiar with it, this is the third generation of data protection law in the UK. It incorporates everything that you might know already about the GDPR, including how it's going to be enforced. And it does mean, therefore, that post-Brexit, we are still going to have to comply effectively with GDPR because it is ingrained in the Data Protection Act. Okay. So effectively, you know, each member state of the EU has to adopt the GDPR. Okay, and our Data Protection Act is our adopting of that law. Okay, and there are areas of the GDPR where member states can decide how they want to implement specific bits, and this is what the Data Protection Act does for us. Okay. So it is still quite new to everybody. It only got royal assent on the 23rd of May, 2 days before the GDPR. So if you don't feel ready, I don't think the country feels ready. So hopefully you don't feel alone. Yes. So what I've done here is gone through and I've picked out references to employment, okay, that weren't otherwise covered or totally clarified by the GDPR. And we've just got a few slides on this to end on. So sensitive data, first of all. Now it is referred to as special category data in the GDPR, but it's the same as sensitive data, okay, in effect. The GDPR actually prohibited any special category or sensitive data from being processed full stop, unless you had set criteria, okay? But the Data Protection Act says that you can process this information for the reason of employment, okay? So that's good. That's clarity straight away. We don't have to try and find an excuse to have the information we need. We did have one if you cared to know, but now we've got a clearer one. Okay, so by reason of employment, we are allowed to have sensitive data in our organisation, so long as it is only processed for that reason. We can also process it in connection with providing an occupational pension. Okay, now there are certain conditions for this, and again, if you did want to speak to me further, please do get in touch for some advice. But in effect, you know, if you are operating an auto-enrollment pension scheme, then you are allowed to process sensitive data, and it includes sensitive data of relatives, because sometimes they ask about, you know, relatives, conditions and things like that, and this allows us to process that information without the consent of the relative. Equal opportunities. Again, it's something that we talk about quite a bit on some of our seminars that we do, and we end up discussing, you know, whether or not it's something that is always needed, actually, you know, depending on the size of your business and the person recruiting and how good your records are, you know, on why somebody was appointed to a position. But The Data Protection Act does make it clear that we are still allowed, because the GDPR was not clear. In fact, it didn't discuss it really. But we are still allowed to process data which is necessary purely to work out whether or not there is equality and equality of opportunity and treatment in our organisation, okay? Or if there is an absence of equality or of opportunity or fair treatment. So purely for that reason, we can process sensitive data, but only data that relates to racial or ethnic origin, religious or philosophical beliefs, health, and sexual orientation. Okay. It would be unlawful to process personal data under this excuse purely to make a decision in respect of one individual, okay, or if the processing was going to cause substantial damage or distress, okay. And there are some other reasons too. But the Data Protection Act also gives us permission to process sensitive data to promote racial and ethnic diversity at senior levels of organisations. Okay, so some specific rules around that as well. A data protection policy. So, yes, it is confirmed. Probably thought we had to anyway, but employers are required to put an appropriate policy in place about data protection. And as well as other indicators we had from GDPR, we've got these 4 specifics here. So it must explain how our procedures are in place in order to comply with the principles of the GDPR. So there are 6 of those, again, discussed on previous webinars. The policy should also explain your stance on retention and erasure of personal data, okay? So it's got to indicate how long you're keeping personal data for. If you did want to come along with us, if you aren't already, or for those of you that are with us, we've got general data protection policies ready to go for you to download, as well as retention and destruction policies. And if you don't have access, inquire. Go back. You also need to make sure you're reviewing this policy, okay? So if there are ever developments in terms of codes of practice or changes in your organisation that are quite specific, you know, which are detailed in this policy, then you would need to update it. And it also specifies that you have to make this policy available to the ICO if they should ever ask for it, free of charge. Records of processing activities. Okay, so again, there is a previous webinar available on our archive that you can all go and watch. And I think it was the 4th webinar that I did in the compliance, preparation for compliance series. Now, there was ambiguity in the GDPR about whether or not every employer had to keep records of processing activities, and that has now been clarified, okay? So the Data Protection Act does say that employers must maintain these records, okay? So in addition to everything that the GDPR said that we had to keep, we also must confirm that any sensitive data is only processed by reason of employment. Which of the 6 legal grounds for processing personal data is applicable? And just on that, there are 6, and some people try and put in as many as they think are possible, just to cover all bases. But they are very distinct legal grounds, okay? And it probably is only the case that only ever one of them, maybe maximum 2, would ever apply at one time, okay? So do try and be specific there. And then lastly, whether or not you retain and erase information in accordance with an internal policy. And if not, why not, basically. And second to last then, infringements and whistleblowing. So this act does say that employers have got to put in place an effective mechanism, so probably a policy, to encourage staff to report any infringements of data protection laws. Okay, so think policy, think training programs and training material and refreshers and things like that. Employees need to be told, okay, who they've got to report infringements to. So when I say infringements, this is the wording in the Act, but we are pretty much talking about breaches of data, but also any other kind of infringement of data protection law that they may witness going on, either internally or in other organisations that you work with. Okay. So staff must know that they have to report that either to the data controller, okay, so again, probably embodied by your managing director or CEO or someone to represent them, or the information commissioner's office itself, okay. So they should know that they've got to go either to that person or to the ICO. And you also need to discuss the fact that they will be afforded protection under whistleblowing, okay, for reporting an infringement. Okay, now, if they're genuinely reporting an infringement, then any confidence that you might feel that they owe you as your employee is not in breach. Okay, so you wouldn't be able to look at dismissing somebody for a breach of trust and confidence. And equally, if you had any sort of non-disclosure agreement in place, but they reported this infringement, they would not be in breach of that non-disclosure. And lastly then, so I know we're a little bit over the hour and you might be feeling a little bit ready for a cup of tea now or something. This is still quite an important one if you can just keep your attention a little bit longer. Medical and criminal records, okay? The DPA is actually quite clear that it is an offence, okay? It will be an offence for an employer if they required, so that's an important word, required a candidate, an employee, or any other data subject to provide them with access to relevant records, okay? And relevant records are, in effect, medical and criminal records when you look at it. In connection with recruitment, continued employment, or the contract for the provision of services, so undertaking a contractor or a self-employed person. Okay, it would be an offence to require somebody to give you that information. Okay, now it was always the case before that you couldn't force somebody to tell you, you know, about any ailments and things like that they have, but this now makes it very clear that you must not require somebody to give you that information in respect of these things. And further, in terms of health records, contracts. So it can be common for contracts of employment to include something about, you know, we will need, or hopefully we may need, you know, access to your health records should it become necessary to support you in connection with your employment and your medical capability. But any contractual term, and again, the Act specifically says this, any contractual term will be automatically void if it requires a member of staff to supply the employer with that information. Okay, so please go back through, check your contractual wording. If you know anything about contract law as well, you might know sometimes it's the case that if one clause is void, then sometimes it can void the entire contract. So please, please review and make sure it's careful in the wording with regards to that. Okay. And so that is it from me today. Now, if any of you do, please do, you know, use our HR knowledge base, or if you want to access, please let us know if you're interested a bit more about it. We're going to be uploading so much stuff this month and next, especially now we've got all of our legislation in place to help, with preparation, with getting privacy, notices, consent, references, subject access requests, anything and everything really that may be data related, we're putting up there to help you with. So have a little look or ask us about it. And we're trying to be social, which is nice. So if you're on any of these, please follow us or be our friend or whatever the kids say these days. It would be great. We do send out sort of smaller nuggets of information, which is helpful, especially if you haven't got the time to sit down for an hour and listen to a webinar. So have a look at these and connect with us. But as I said at the start, and I'll end with it too, if you have got any questions about the content of this webinar today, please do drop me an email. I will try and get back to you as and when I can, but I would be very happy to answer any questions you have in connection with anything that I've said today. So thank you. It has been a long session and thank you for joining us. Much appreciated. I will hopefully see you again another time. Take care. All the best.